the first to know. Nsem-Pii TV.
In the history of Ghana's republic, ye name any form of judicial precedent a ebetimi a compare to this particular case. Na intia yenya from the camp of lawyer Tsatsu Sory and a lawyer Bakavoma was say lawyer Tsatsu ama Sory say sa particular rate we there nanka ontene na ono lawyer Tsatsu nkasa enrobu no ombejina the court, because this particular case a case between her ladyship herself, Justice Torkonoo, represented by the former Attorney General Godfrey Dame, against 1. the Attorney General, 2. Justice Gabriel Scott Poamai, 3. Justice Samuel Kwame Adibu Asiedu, 4. Daniel Yao Domelovo, 5. Major Flora Dalugo, and 6. Professor James Sefagisa. You see, cases Honorable Vincent Asifua, a presenter, na a Honorable Vincent Asifua, represented by Godfrey Dame, as against the Attorney General himself alone. But ye name in command akoswa, after the Honorable Vincent Asifua pulling out after judges what's the name? Judges a constituting year omuka say omumpene enfa injunction entro the process, the investigative committee President Mahama Apau. All of a sudden, Honorable Vincent Asifua say we train rate from the court. You know what is happening. And a second rate essentially PMO from Mr. Theodore Saki. Now, what is unprecedented? Say, Rebecca say Assistant Chief Justice, because she's only suspended, but Omunyino on one kasa and a actual rate way. Now, a Supreme Court Chief Justice are represented by a lawyer. The kind of knowledge, the kind of legal knowledge back in that particular rate way, lawyers based on a case way for the next 100 years in Ghana's Republic. Now, you go into this particular rate filed by her ladyship, Justice Gertrude Isaba Saki Torkonoo. Now, rate way by any it say normally Godfrey Dame and Theodore Sory and a tie argue in this case with Chief Justice seated, but entirety from the camp of the lawyers of the plaintiff, they say this particular rate with the way the enormity of the rate lawyer Tsatsu himself osanso ba because he historic. Now go into the rate and the reliefs are Chief Justice, her ladyship now normally reliefs are you who say rate tie carry maybe 4 reliefs, 5 reliefs, 6 reliefs, but where there's 16 reliefs, 16 into waiting I say International Criminal Court for monitor this particular legal battle, and a lot of international community monitor, because for a sitting Chief Justice himself, so all they all solicited from the Supreme Court unprecedented. 1, in the name of the Republic of Ghana, you are hereby commanded where a rate to the Attorney General, as well as what the 5 investigative committee members: Justice Gabriel Scott Poamai, Justice Samuel Kwame Adibu Asiedu, Daniel Yao Domelovo, Major Flora Nara Dalugo, and a Professor James Sefagisa. Now, what is interesting is a very, very interesting say her ladyship, Chief Justice, but at the investigative committee members never come, because I'd say investigative committee members need there or a shrunken from that of the Attorney General, but in Commodore Koso say omu miti Justice Kwame Adibu Asiedu with Unicolendi with Theodore Sory Asia in at airport residential there, and I say and a more carbum dia muni na mun carbum ni Supreme Court. she is moving the Nkomodie no, Edumadie no, from the premises of the investigative committee. Say on ye better say ye better say war castle, say ye better say war security so dabi yam say war the Supreme Court. Ne ndim komono wo ho. Now, nature of the reliefs are what they are serving both the investigative committee and the current Chief Justice. One, a declaration that upon a true and proper interpretation of Article 17(1) and 2, 1913, 14, 1467, 8, 28. Oh no, Pacho, wait there. Forgive, say me so excited, but what most this particular rate, articles are ya listed no. More than normally rates I tell Obua rate be wa but what 3 rates be 3 articles be with subsections. Anything a bit excited, but you be control near Sanko. 1, a declaration that upon a true and proper interpretations of Article 17(1) and 2, 19, Section 13 and 14, Article 146, Section 7 and 8, Article 281, Section 1 and 295, Section 1 of the 1992 Constitution, a Chief Justice has the right to a public hearing in proceedings before a committee appointed by the President to inquire into a petition presented for the removal of the Chief Justice. Amonfa sa interpretations to based on sa articles we. 2, a declaration that upon a true and proper interpretation of Article 17(1), the same articles was the above, and 2, 1913 and 14, 23, 1467 and 8, 2811 and 295 Section 1 of the Constitution, the right of a Chief Justice to a public hearing and all the incidents of a hearing may only be executed in the interest of public morality, public safety, or public order. Ajay, share this particular case, Chief Justice Edeba before the Supreme Court, already say or fight for or no any personal interest as Chief Justice. Na omu nim na omu ditiano as Chief Justice. Na omu boss and rate we na totally gua. All Chief Justices are ebeba after this Constitution omu becherom, because ma oshe articles are one listed. Na mu boni case na egu 4-1, 4-3. Na Chief Justice beyond betinasa ni mu be ha. Now you call the third one. A declaration that upon a true and proper interpretations of Article 17(1) and 2, 1913 and Section 14, Article 23, Article 146, Section 7 and 8, Articles 281, Section 1 and Articles 295, Section 1 of the Constitution, a Chief Justice who is called upon to participate in a hearing conducted by a committee under Articles 146, Section 6 to inquire into the merits of a petition seeking the removal from office of a Chief Justice can waive the privilege of in-camera proceedings. Enti se privilege na ombode man say in-camera because oye penny enti yentimi emma ho kwan emma sebe ne nemu nguase enti ne ye ne secret no omonsan state say ono na privilege ne benefit no as Chief Justice ono na mo pese mo protect ni office ni image as Chief Justice enti ono ankasa a benefit ontimi nkasa mwana mo se mo pese mo ye ni in camera afraid based on the reputation of the Chief Justice. It's not any be just for the office to protect the office. Into no Chief Justice now or occupies her position. Won't mean kasa me pana. Is it by force? Say privileges are modiama. You say we have yababe arrest you bia. You see, you have the right to remain silent. A privilege. Say one kasa. Say ne ya asama wo be kan ending tiao in court. Ono one kasa na privilege ne benefit no. Ono ntan betima kasa. Mekasa they defend me ho. Inti mo nti kasa because you have the right to remain silent inti. Chinchina chi yedin ana. As soon as Chief Justice remain in the third relief they said. Omo articles we now were listed. Articles we now were listed. Now omo kan say or no Chief Justice in that particular office no can she waive the right of in-camera proceedings. 3. In Japan say we did here now. Subsequent Chief Justice ebeba secretly mo bet ma boni a investigative committee ya che prima facie a investigative committee na ma betra so na pa mo yi no for the next concurrent government. And I'll share the nature of this particular writ compared to Honorable Vincent Assefuade no put him say we no wait a womb no eso papa because Honorable Vincent Assefuade and the crap they no call for the suspension interlocutory injunction in him. But Oshe relief, sir. Chief Justice Watrona, you move on. 4th relief. A declaration that upon a true and proper interpretations of Articles 19, Section 13, 23, Article 146, Section 124, and Article 296 of the Constitution, a determination of a prima facie case in respect of a petition for the removal of a Chief Justice or a Justice of the Superior Court of Judicature is a quasi-judicial process requiring a judicious evaluation culminating in a reasoned decision. Enti, se mo ba be Chief Justice a quasi-judicial process require a judicious evaluation. It requires the supervision of the Supreme Court. It requires the supervision of office of the judicature. Inti enye edumedia otibe kwache only executive man ye. Enye edumedia ultimately baby akeke. Chief Justice man ye. Edumedia the involvement of the judicial process must be seen. It is a parliament crapona. Yes, it's not to say a justice system. Now, 5. A declaration that upon a true and proper interpretations of Articles 19, 13, 23, Articles 146, Section 1, 2, 4, and 6 of the and Articles 296 of the Constitution, the purported prima facie finding in respect of 3 petitions presented for the removal of the Chief Justice and served on the plaintiff by a letter dated 22nd April 2025 does not amount to a proper determination of a prima facie case and therefore null void and of no effect. And the petitions are Mr. Daniel Rofori, petitions are Shining Stars, petitions are ACP, IAMGA, Ede Bayern, or challenges are petitions dated on 22nd April 2025 say it does not amount to a proper prima facie case and therefore null, void, and of no effect. Thou shall this particular relief, Honorable Vincent Assefuade called Omaboy Chuegu. On Mr. Theodore Saki Theodore Saki so edekoi omobotugi because nkofo bebe na challenge President John Dramani Mahama and Council of State's determination of prima facie case. Into this particular 5 idea very shaky, but o share articles or the account ultimately say articles no endorse saying previous challenge of the prima facie case. 6. 16 year 6, a declaration that upon a true and proper interpretations of the same articles, the same articles, we repeat you, the purported finding by the president that the prima facie case has been made against the plaintiff and served on the president by the same date, 22nd April 2025, was arbitrary, capricious, in violation of the right of the plaintiff to a fair trial and therefore unconstitutional and of no effect. Enti a kwan of us so determine a prima facie case against or no chief justice no. Or say one, a fair. Two, a unconstitutional, a arbitrary, a capricious, and a violation of the rights of the plaintiff, that is the chief justice. 7. A declaration that upon a true and proper interpretation of articles, the same articles, purported determination by the president that a prima facie case has been established against the plaintiff and conveyed in the same letter 22nd April 2025, together with the warrant of suspension of the plaintiff, constitute an unjustified attempt to remove the plaintiff as head of Ghana's judiciary and thus an undue infringement of the independence of the judiciary. Share articles about Boma, a chief justice Nankasa na yene own lawyer. Godfrey Gebo Adame there, or rehash some of the arguments of the chief justice. We a very, very powerful case because the plaintiff no ain't necessarily a lawyer or a chief justice. And I go for the word Dame Virginia, more or less, represented. Now, I say 7 or say, sir, a quite of us so a determined prima facie case no a unfair, arbitrary, capricious. Now 7 now, I also say an unjustified attempt. A choir on person of faso, the head of Ghana's judiciary, an undue infringement on the independence of the judiciary. Into Ghana's constitution, a case 1, the executive shall be free. 2, the legislature shall be independent. 3, the judiciary shall be independent. After the executive ne person of a so no control judiciary. Now, I say President Nana Danko Kufuor when your legislature a favor no in the person of Speaker Alban Babi. Now, because on person scenario, all fasa kwai be so capricious, arbitrary tactics be the Speaker of Parliament na send ya the Speaker of Parliament be rehash be ye enyema or no open. That is what the 7th relief about. Say because the executive per se judiciary no independent or person of fact crime be so no ye the head of Ghana's judiciary and that's an undue infringement on the independence of the judiciary. And this is why I say Tado Sory so alternate lawyer Tsatsu himself, where the most historic case in the independence of the Republic of Ghana, based on cases a young Ghana, because I say that case we lawyers based in the next 100 years. 8. A declaration that upon a true and proper interpretation of the articles 1466 and 7 of the Constitution, the failure to serve the plaintiff with a judicial determination of a prima facie case before appointing a committee to purportedly inquire into the petitions of the removal of the plaintiff as chief justice constitutes a violation of the plaintiff's right to substantive and administrative justice, fair hearing, render the entire process initiated null and void. We say one determined prima facie case against a plaintiff. And send a investigative committee ashushimuno. Plaintiff will determine a prima facie case against the person. One person on one person, 17 petitions. A quite one man, a quite crap say, or be defended in any way or form. Until the whole process, it should be initiated null and void. Some person will be fair. Now, wait here, it is going to be a very, very heavy burden on constituted panel. 9. An order setting aside the warrant of suspension issued by the president dated 22nd April to suspend the plaintiff. Until judiciary and pass an order to suspend the suspension. This particular relief also honorable visitors for other persons and draw 4-1 from the Supreme Court. Now Mr. Todosake so demanded this relief, but based on the name Chief Justice reason, the best say on best set aside this suspension now. Eti utimi hu say from the way or challenging this particular case in the Supreme Court, or were very, very little confidence in the process of investigative committee, that is the Justice Torkonoo Committee. Done deal. 10. A declaration that upon a true and proper interpretations of Article 23, Articles 1466 and 72968, the same articles, that the second defendant, Justice Gabriel Scott Poamai, is not qualified to be a chairman or a member of the committee set up by the president to inquire into the petitions against the plaintiff on account of having adjudicated and giving various rulings in favor of one of the petitions done on Sory in actions filed in the Supreme Court. Into 10, what challenging Justice Poamai. So, a dear petition a year so ama wo the ruling abai in the investigative committee. One kasa what's that case so am obi hu adwene dada. Enti ade ebiem ne yakwakoka ewo ho. Wo the ruling aba enti that process no be fair. Na case he has to be an independent justice. On that case no so. 11. An order prohibiting the second defendant, Justice Scott Poamai, from presiding as chairman of the committee or participating in the proceedings of the committee set up by inquire into the petition against. And Justice Poamai crying in free committee in so cry. Now you see what is even interesting is these reliefs are separate. Into say Supreme Court and agree with her. Now go ahead setting up the investigative committee. The likelihood is or so call for say or bet trusted process and say Justice Gabriel Scott Poamai and yes or 12. A declaration that upon the true and proper interpretations of the same articles already in lesson 23, 127, 146, 296. The appointment of the third defendant, Justice Kwame Adibo Siedu, as a member of the committee set up by the president to inquire into the petitions against the plaintiff at the time when he had already sat as a member of the panel of the Supreme Court, constituted under Article 1282 of the Constitution to hear an application for the interlocutory injunction filed by a Ghanaian citizen challenging the Article 146 proceeding initiated against the plaintiff violates the independence of the judiciary. Articles Relief 10, Relief 11 is against Justice Scott Poamai. Relief 12 is against the membership of Justice Samuel Kwame Adibo Asiedu. Ayasem Yanko. Relief 13. An order prohibiting the third defendant, Justice Samuel Kwame Adibo, from sitting as a member or participating in the proceedings of the committee set up to inquire into the petitions. Relief 12. Ekase already no interlocutory injunction bi aba na esi ho kwan say omonto asa investigative committee eduma do so Justice Kwame Adibo etena so ebotugue enti eba ne sen na utimi a panel of one process na wasan so akwa investigative committee ni so say mo na mo ba be determine say prime facility nya ya pra na ni it's a part say who vested interest in the case a person who say a particular outcome be paid in this idea. Relief 13 yenye Justice Kwame Adibo Asiedu free so unprecedented into where judges against judges case na ye de bremo. Relief 14. A declaration that upon a true and proper interpretation of Articles 1461 and 2, 4, 23, 296 of the Constitution, that the 4th, 5th, and 6th defendants are not qualified to undertake the functions entrusted on them as members of the committee set out by the president to inquire into the petitions against the plaintiff. That is Mr. Domelevo, members of the academia, members of the Ghana Armed Forces. Yenti okasa omo qualified and say already no was seeking relief be what top or say a judicial process. It is a nipa what national must be nipa when you the training of judiciary in Ghana, either called by the bar, being a lawyer, or being a judge, justice. There's a judicial process. Move with him, training here, saying, we are an ultimate audit. Ebe understanding a quasi judicial process. 16. Any other orders as this honorable court may see. You see, this is judges against judges. Case near the Abraham. Now the plaintiff brings this action as a citizen capacity, as a citizen, in terms of Article 2.1 of the 1992 Constitution, affected by multiple constitutional infractions, implicit in her suspension as the Chief Justice of the Republic and the constitution of a committee purported to inquire into the petition presented for her removal as Chief Justice. And the capacity, one, already Nankas being a citizen of the Republic of Ghana enough, but or the capacity as a Chief Justice on Swakamu and was serving the Supreme Court. And the Chief Justice rate way AG a Jumane free investigative committee justice for mine or Majuma or Mokakoye share with security zone. No, let's meet at the Supreme Court. Where in Nsem-Pii TV? You did this special rate. It's a privilege. Say any this opportunity and this a special rate we abremo from the Supreme Court. Solicitor by Godfrey Yeboah. Dame.